Mode.
Welcome everyone. I'm Shawn O'Connor.
And I'm Shawn Van Helden.
And we have a large turnout today. And it was a very interesting start to our year, and we have wanted to highlight a few cases for you that have just come to our attention. And we would invite everyone to email us your questions as we proceed, and we'll save time at the end to address them. And don't forget that we are going to email you the PowerPoint presentation after the webinar, so just take notes. Don't worry about having to copy down the details. I hope we've set these out in the slides for you. So today we want to talk about these topics, and hopefully they're matters that have already come to your attention, and there's probably been some discussion in your office, and as I say, we appreciate hearing from you how you're dealing with some of them. Shawn will start with the first one. What is an accident under the SABS?
So I think these two cases are interesting in that they present an apparent contradiction. The first case, Downer v. Personal Insurance, dealt with a gentleman who was assaulted while he was parked at a gas station counting his money in preparation to pay for the gas. He escaped by putting his car in gear and driving away, and he thought that he ran somebody over as he did so. So he had made a claim for psychological and physical injuries. The second one, which has gotten a lot of press, and I expect some of you have probably heard about it, is one involving a gentleman who broke his neck while performing a headstand on a luxury limousine coach, and he was trying to do a headstand against a stripper pole. So surprisingly, in this case, the first was found not to be an accident under the SABS, and the second one was found to be an accident. And the reasons may not be intuitively obvious. The cases do present entirely divergent views. In the first case, counting money for gas is something we've probably all done, and probably have all done it in the car, and is arguably an ordinary and well-known activity to which automobiles are put. On the other hand, doing a headstand against a stripper pole and falling on your head is, I can count the number of times on one hand that I've done that in my car. Yeah, you go next. And it's probably not something we would think as an ordinary activity to which autos are put. And the key in this case, I would note as a preliminary note that both of these cases were decided under the old SABS, which defined an accident as something that directly or indirectly causes impairment or damage, whereas the current SABS from 2010 on rely only on directly causing impairment or damage. But the key to reconciling these cases is the causation inquiry. What actually caused the injury? So in Downer v. Personal, the Court of Appeal applied a very strict application of the modified causation test under Chisholm. And the first question to ask was the use or operation of the vehicle a cause of the injuries? And in that case, Downer didn't even get past the first part of the test, because it wasn't the use or the operation of the vehicle that caused the injuries. It was a fist coming through the window and hitting him in the head. And unfortunately for him, that is not something that we would ordinarily think of as an ordinary well-known activity to which automobiles are put. In the second case, though, the use of the stripper pole in the context it was being used was actually found to be an ordinary and well-known activity to which the limousine buses are put. And the issue in that proceeding should be assessed against the backdrop of the type of vehicle that was being used, which is a mobile party bus, which the court found it was expected that the occupants would be cavorting around a stripper pole under the influence of alcohol. And those two factors were important in the court's decision. Moreover, all of the parties agreed that the presence of the stripper pole actually invited the cavorting activities around it and with it. And so this was a case of a busload of guys coming back from a golf tournament, drinking, and participating in stunts around the stripper pole that escalated to the point of Mr. Whipple attempting a headstand, which resulted in his injuries. So with respect to some implications, in the accident context of accident benefits, we really need to scrutinize the cause of the injury in the context of the use of the vehicle. In Downer and Personal, the court highlighted that it's not enough to show that the automobile was the site of the injury or that it was somehow involved in the accident. The operation or use of the automobile must have directly caused the injury. And the Chisholm v. Liberty Mutual Group case from 2002 dealt with a gentleman who was unfortunately a victim of a random bullet coming through his window. He was not the target of a drive-by, but merely in the wrong place at the wrong time. And while the court highlighted that an intervening act may not resolve or absolve an insurer of liability, in most cases it could actually be a barrier if it's not considered a normal incident of the risk. With respect to underwriting, is particularly in cases dealing with party buses and automobiles that are put to uses other than getting from point A to point B, we just may want to examine the precise contents of the vehicle insured and what the activities are that are being encouraged to make sure that the risk is being valued and assessed appropriately. And also keep in mind that for accidents after 2010, the language of the Court of Appeal seems to be mirroring the new language. You'll notice that there's no reference to indirectly causing the injury under their application of a modified causation test. They state that the use or operation of the motor vehicle must have directly caused the injury, and that is precisely the language that is now captured in the accident benefit schedule.
The next case is one that anyone in dealing with accident benefits in your office has probably had to deal with. It's a decision released on March 30th of this year, Parveen Vs Aviva. And in the slide, I've set out the timeline. This is a case which, at a pre-arbitration telephone conference, the parties, of course, are having settlement discussions, and in fact, they reach a settlement. And on the 30th of May, the settlement disclosure notice is sent out and is signed, and that's the same day as the telephone conference. The June the 1st, counsel sends us a release that they've drafted over to counsel for the insured. And on June the 10th, there's an email back from the insured's counsel saying that they had a problem with the form of the release and asked if the settlement required the release, and indicating that there wasn't going to be a settlement if the release was insisted on. They have some further discussions, and on July the 4th, the insured actually signs the release, and on the 5th, his lawyer says, my client has rescinded the deal, here's all your documents back, and there's then an exchange of money going back and forth where the check is being sent back and forth between the offices. So what happens next, of course, is Ms. Parveen, having rejected the settlement, goes on to ask for the arbitration to be scheduled, and so Aviva asked for a motion on a preliminary matter of whether they could proceed to the arbitration because there had been a settlement. So that motion was back in November of 2011, and arbitrator Alves released her decision in March 30th, and the nub of her decision was that the settlement disclosure notice refers to the possibility of a release being signed, being requested by the insurer, but it does not refer to that release in respect of the 2-day cooling off period. And she found that the disclosure notice does not contain a statement that the insured person may, within 2 business days after the later of the day that the insured person signs the disclosure notice and the day that the person signs the release, rescind the settlement. And she found that to be a defect in the form, and therefore there had not been a settlement effected. In making that holding, she deals with the fact that the form is prescribed under the regulation, and simply says that an insurer is responsible to see that the settlement documents comply with the regulation, and that there is no prohibition in altering the form to ensure that it does. So if you looked at the FSCO website, you'll see that they have put up a notice of a discussion point on this. They're indicating they are not going to change the form. They believe that the form complies with the law. So what are we doing? Well, initially, I think a lot of insurers were saying we need to stop having discussions about full and final resolutions, but in the end, that's not in anyone's interest. And so we're beginning to see some fixes emerge, one of which, of course, is to address the problem of having both documents, a release and the settlement disclosure, signed at the same time, or have the release signed first so that the disclosure document, which says you have 2 days after this to cool off, it complies. There's no reason, I suppose, that a release could not be amended to specifically deal with that, but I think the problem still is the fact that the form doesn't refer to it. So some insurers are asking for additional documents in which the dispute in this case is acknowledged and ask for a waiver of any defects in the form. So it's going to continue to be a challenge, and I think that, as I say, it's in no one's interest to let these matters simply proceed to arbitration because we can't adjust the form, and I think by experience we'll all be fine-tuning those.
So next, we'd like to talk about Momentous.ca Corporation v. the Canadian American Association of Professional Baseball. I recognize that many of you may have read the article in the Risk Management Council of Canada's website, which was written by Samantha Ituragi, who is one of the lawyers here at Kelly Santini, who attended the Supreme Court of Canada to argue this motion along with Pat Santini. By way of background, the Can-Am League is comprised of, not surprisingly, Canadian American baseball teams, and during the 2008 season, Rapids Baseball told the league that it was not going to be operating the following year, and it requested a withdrawal based on financial hardship. The league rejected the application and held that an arbitration before the league's board was necessary. They terminated the team's membership, they drew down a line of credit, and underlying all of this was the fact that Rapids Baseball had signed a number of contractual agreements with the league. The agreements included form selection clauses, and it stipulated that the North Carolina courts had jurisdiction over any litigation and that North Carolina law would be applied, and in addition, the agreements provided that the disputes would be handled by arbitration as the exclusive remedy as opposed to litigation. Now, despite all of those clauses, the form selection, the choice of law, and the arbitration clause, after the failed arbitration hearing was held, Rapids Baseball and some related companies sued the league and its principals, along with the City of Ottawa, in both contract and tort. Now, we represented, as I said, the Canadian American Association of Professional Baseball, and the plaintiff argued that if we had wanted to dispute the form, we should have proceeded under Rule 17, which requires that after being served with the claim, the defendant would move for an order to set aside the service or stay the proceeding under the grounds that the service is not authorized under the rules or that Ontario is not a convenient forum. What's important is that that rule requires that the motion be brought before the party delivers a defense, or even a notice of intent to defend, which would be construed as attorney to the jurisdiction. Instead, in this case, we defended the action, and then we subsequently brought an application under Rule 21, which allows a defendant to seek a stay or a dismissal on the ground that the court has no jurisdiction over the subject matter of the action. And that's an important distinction because what Mr. Santini was not contesting was the Ontario court's jurisdiction over the action per se, but just saying that the subject matter of the action lacked, or the Ontario court lacked jurisdiction because of the contract clauses. So when the other forum, in this case it was an arbitration panel, has exclusive jurisdiction to deal with the claim, the Ontario Superior Court should not take jurisdiction based on the agreement and the statute. And the Supreme Court of Canada agreed. So unless there is strong cause to displace the form that the parties have agreed to, the ideas of order and fairness are better achieved when the parties are held to their ends of the bargains. So the Supreme Court held that the motion judge, who initially found for our client in this case and dismissed the action under Rule 21, had made the appropriate decision. And the motion was brought promptly following the defense, but there's nothing in the rule that requires it to be brought before the delivery of the defense. And strategically, this is advantageous because if this motion had failed, then the insured still had the defense in before the court and was ready to proceed with the defense and the merits rather than being caught with potential cost implications for delaying the action. This is great news for us in terms of suits dealing with breach of contract and tort. I've actually had the opportunity to apply this one recently in a small claims action, and it was an action in which we were third-partied by a defendant who had been sued by a plaintiff. for a matter that was a contractual issue between the plaintiff and our client. We defended the action, sent along a copy of this case, and a request that we be let out of the action without costs, or we would pursue a motion which was almost certain of success on the findings of the Supreme Court of Canada, and we were able to resolve that matter and extricate our client in a very short period of time.
The next case I want to talk about is an April 27th decision of the Ontario Court of Appeal on a coverage issue and duty to defend. And Durham District School Board sued the parents of a child at the school who was involved in an arson. The child had set fire to the recycling bins at the school, and the fire had spread to the school building itself, and there had been significant damage. And so as a result, there was a claim against the child for causing the fire intentionally, and then there was a claim against the parents. And the claim against the parents is that they failed to do their job as parents. They didn't provide a curfew, and they didn't enforce a curfew. They didn't supervise their son when they knew they had a propensity for getting into mischief, and that they failed to adequately discipline the child, and they failed to properly and adequately instill in their child a respect for private and public property. So the parents brought a third-party claim against ING for indemnification and for defense, and ING then brought a motion to determine that it wasn't obligated to defend and that the third-party actions should be dismissed. And so there is the exclusion clause, which we have in our next slide for you, that was in the policy. Not an unusual form of words used in these types of policies, although every policy is slightly different. And what the court said was that the exclusion clause could be read in two ways. First, the clause could be read so that the words intentional or criminal modify the phrase act or failure to act. And read that way, the clause would only exclude an act or failure to act that is intentional or is criminal. Alternatively, the clause could be read to exclude an intentional or criminal act and any failure to act. So read in this way, the clause would exclude a failure to act that was merely negligent, and therefore the judge adopted the second interpretation. And the problem, of course, is the general principle of interpretation of insurance clauses is that they're resolved against the drafter of the clause, that coverage clauses are read broadly, exclusion clauses are read narrowly. And so that they looked at Lloyds versus Scalera for guidance, and in the end, they held that this claim against the parents was not the same claim that was being made against the child. An intentional tort was being alleged against the person who actually set the fire, and that what was being claimed was the failure of the parents to carry out their duty as parents and a failure to act in the way that parents should act. And therefore, the Court of Appeal said that the elements of the intentional tort claim against the son and the negligence claim against the parents were entirely distinct, and that the negligence claim was not derivative of the intentional tort. And the court paid lip service to the idea that it's not the words that determine the court's outcome, it's the true substance. And in this case, what they found was an ambiguity, and then turned to the substance and said that this had the claims were distinct, were not derivative, and therefore there was a duty to defend. Sorry, and so we're just, in terms of I'll just give you the citation, what the Court of Appeal had said.
Now, on the heels of that decision is a truly heartwarming decision out of the Ontario Superior Court here in Ottawa that affirms that a broad and clearly worded exclusion clause can and will apply. The facts of this case are that Xavier Desormeaux, a very young child, was playing in his grandmother's yard when another child who was also in the yard threw something that struck him in the right eye. And as a result of that injury, he has lost his sight in that eye. The Desormeaux family, consisting of Xavier, his mother, father, and sister, started an action against the grandmother who owned the house and the property that he was attending at the time, the other child, and that child's mother. All of those defendants filed counterclaims against Xavier's mother, Sophie, for contribution and indemnity towards her son's injuries, and, as in the previous case, they alleged that Sophie was negligent in the supervision of her child, and at the time Xavier was under her care. And during the hearing of this application, plaintiff's counsel or applicant's counsel made it clear that the allegation of negligent supervision went far beyond just the activities of that day and were meant to encompass the lifetime of a failure to properly supervise, educate, and properly rear the child. So in this case, Mr. Santini argued for the respondent, and Justice Annis found that a broad, clearly worded exclusion clause applied, and as a result, the homeowner's insurance provider was not required to defend the insured against the counterclaims for negligent supervision. The core of the court's analysis begins at paragraph 27, and what we really like about this decision is it's one of the most lucid decisions that we've seen applying the recent case law of the Supreme Court of Canada with respect to exclusion clauses. And in particular, one of the elements that we focused on was that the exclusion clause must be read in light of the initial grant of coverage. And Justice Annis adopted our methodology of piecing together the two texts, the grant and the exclusion, even though they're actually found pages apart in the policy, and reading them as one sentence or one thought. In the written decision, he left in the headers and such for the apparent clarity of the decision. In my opinion, it's actually clearer to read it without the headers and read it as we presented it in our factum, which was conveying the grant and the exclusion as one sentence. And as you can see also here on this screen, the interpretation of the phrase, "this policy," was also critical to the finding and the subject of much debate at the hearing. Yeah, next one. So just to close the loop on that, the policy wording in this one was really preeminent. Advocacy can only go so far, and there's no substitute for good writing and good drafting. It's very difficult to overcome poor drafting, in fact. But our suggestion would be read the exclusion clause and initial grant of coverage in any case where you think this might pop up, and read it as one sentence. And that would be a simple matter of drafting the initial grant of coverage and then reading the exclusion afterwards. And again, in this case, it benefited from both the precise language and also the fact that the exclusion clause referred specifically to coverage E, bodily injury, so there's no ambiguity at all as to what was excluded. And with respect to whether or not the claim was derivative of the main action, again, the hearing, it's not mentioned in the written decision, but at the hearing, the court did entertain discussions on whether or not the claim for bodily injury was somehow distinct from the claim for negligent supervision, as in the Durham School Region case. And the court actually found in our case that it was not the words but the substance that mattered, as the Court of Appeal had agreed. And in this case, the entire claim revolved around the bodily injuries sustained to the member of the insured's household. So in any event, the claim was ultimately derivative of an excluded coverage.
Thank you, Shawn. The next one is a decision in Federico and State Farm, and that's a decision that was released in March of this year, March the 23rd, and it deals with a number of things, but the interesting part I thought was its decision on the interest rate. And Mr. Federico was injured in a motor vehicle accident in December of 2006, and State Farm had paid IRBs and housekeeping benefits till 2008, and then it declined to pay any further. There was a mediation. They didn't resolve the matter at the mediation, and it went on to arbitration, and the arbitration occurred in November and December of 2010, and then into July of 2011. And the issue that came up after deciding that Mr. Federico was entitled to some ongoing benefits is what interest ought to be paid on them. And so, of course, as you know, before September 2010, we had a 2% per month interest rate, and then one of the changes in September of 2010 was 1% per month. So the question that the arbitrator had to deal with in this case is, what about 2010 accidents with expenses after September of 2010? What rate applies? And the answer he found was 2%. And what the arbitrator held was that the regulation was not clear enough to remove a substantive right to interest, and that the regulation, the bulletin the superintendent had put out on the transitional provisions was not written as clearly as the arbitrator thought it should be, and that furthermore the bulletin is not law. So the arbitrator reviewed the regulations, found that there was no provision which expressly took away the 2% and provided for 1% only, and therefore in a accident which has occurred before the change was made, the substantive right to interest at 2% was not revoked, and it continued even if the expenses were incurred after 2010.
Termination of insurance under statutory condition 11. This case cuts it about as close as you can to the wire in affecting a cancellation of a policy. And the background of this case, it's actually a very interesting one. The plaintiff, Barzo, was involved in a car accident with Lenari, and at the time of the accident, Lenari did not own the vehicle, and it was leased from Chrysler. However, on the insurance application that Lenari had made, he had listed himself as owner. For a variety of reasons, that policy had been canceled for non-payment long before the accident, and the only named defendant in this action initially was Chrysler. Chrysler brought a third-party claim against Perth Insurance, Economical Insurance, which had been the prior insurer of the vehicle, as well as the broker who had arranged for the insurance coverage in the first place. On a motion for summary judgment to have the action, the third-party action, dismissed, the court granted that, and after that motion was granted, the Motor Vehicle Accident Claims Fund brought an application to the court for a declaration that the coverage was actually in place at the time from Perth Insurance, and that the notice of cancellation had not been carried out properly. What's great about this case is the court has upheld that a termination notice which cancels an insured's coverage on the 30th day after mailing the notice is a valid cancellation. In this case, the letter was sent to the insured by registered mail on July 5th, 2007. It specified a time of 12:01 a.m. on August the 4th, 2007 as the effective date of termination. And the argument on the application was whether or not that actually constituted 30 days notice or not. And as you'll see in the chart on the following page, that is actually the 30th day. So in this case, what happened, and I think perhaps a critical element of this, is that the insurer sent this package by registered mail as required under the statute, but also had a copy of the letter stamped and time dated at the post office, so they had proof of when this letter was sent, and they were able to put that evidence before the court to prove beyond doubt that the letter was sent on July 5th. As a result of that, under the regulation, notice is deemed to be the day after mailing, which was at 12 a.m. on July the 6th. And what was interesting was there wasn't really much debate about the fact that July the 6th commenced at 12 a.m. So the court adopted and conveyed in both the hearing of the application and in the written decision some excerpts from the factum that we provided to the court, which is that since the date of determination is to be no earlier than the 30th day after notice is given, it can actually include the 30th day from which notice is given. And this can get a bit confusing in the wording, so I just want to skip ahead to the chart on the next page, which outlines, now the chart we provided to the court actually had every day between July the 6th and August the 4th in there, but you can see what we've done to set it out is to say that service is effective on day 1 at midnight, July 6th. That brings, following through to August 4th, 12 midnight would be the start of the 30th day, and per the letter that was sent, the policy was canceled 1 minute later, which is no earlier than 30 days of the date. And so as far as getting close to the wire. I don't think you can get any closer than this. Within 1 minute of what would be legally tenable and was upheld by the Ontario Court here in Ottawa as okay. It's terrific. And again, I just want to emphasize that what was critical in this case, in our view, is the fact that we were able to prove that this letter was sent on July the 5th. It wasn't just the fact that the letter was dated on that day. We had independent proof from Canada Post that the letter had actually been sent, and therefore the court had no hesitation in finding that under the regulation the first day of notice was July the 6th.
Okay. Next one is a case dealing with attendant care costs, and it's a decision released March 13th of this year by arbitrator Susan Sapin. And this is a 2006 injury, and there was no dispute that the insured required around-the-clock care. And there had been assessments of that level of care that was needed, and the insurer Jevco assessed that at using the minimum wage in Ontario at $7.75 an hour, which gave a total monthly cost of $7,556.41, which of course exceeds the $6,000 monthly maximum that was payable. And so Jevco paid the $6,000 until Mr. FSCO moved to Romania, where his family would look after him. And Jevco took the view that in order to value the monthly benefit for his care costs, it should be linked to what the cost actually was. And Jevco discovered that the Romanian minimum wage was $1.30 an hour, and therefore the same number of hours should cost only $1,596.10 per month. And so arbitrator Sapin had to deal with that dispute, what amount is payable. And so to do that, the arbitrator looked through the amendments to the schedule and looked at what insurers are required to pay, and of course looked at the use of the word incurred, and looked at the use of the Form 1. And so that it rejected Jevco's argument that the minimum wage as they actually were incurred ought to be used, that the legislature had made an effort to remove any hint of uncertainty in calculating attendant care costs, because every Form 1 requires the exact amount of care to be calculated right down to minutes per week for a very wide range of activities, and multiply that by the hourly rate, and that the arbitrator held such minute precision leaves no uncertainty as to the amount and the type of care required or its costs, and found that the form was consistent with the intent of the legislature to provide benefits quickly, efficiently, at predictable cost to accident victims. And that she rejected Jevco's position that all reasonable and necessary attendant care expenses incurred on behalf of the person means actual, and refers to McMichael and Belair, follows that case, which says simply it's sufficient that the reasonableness and the necessity of the service be established, and the amount of the expenditure can be established with certainty. And that the arbitrator noted that the most recent hourly care attendant rate guideline from June of 2010, published on the website, establishes the maximum expense that insurers are liable to pay for attendant care, but the guideline also states that insurers are not prohibited from paying above the maximum hourly rates. It does not say, however, that insurers can pay less. And it didn't even matter that the public trustee was administering this money and actually paying out less to the family members. The arbitrator held that that was not a factor in their decision, and because the schedule set out Jevco's obligation to pay, not the public guardian and trustee's obligation to pay. So just in terms of an update, the failure of the FSCO mediations, you will recall that this spring we had decisions of an arbitrator who held that a mediation failed 60 days after it was submitted to FSCO, and the arbitrator's decision is in Leon and State Farm. And then almost immediately after that, there were a series of cases that were heard together, which we generally refer to as Corney and Security National, in which the court held that injured persons do not have to wait to go through FSCO's mediation backlog because of the deemed failure. They are free to then proceed to sue. So just in terms of what we're seeing happening, number one, the Leone and State Farm case was to be heard by the Director's Delegate June the 18th. So we'll see what happens as the Director's Delegate renders a decision. There is a court date for to be heard by the Court of Appeal in Corney and Security National of July the 18th. And there is another one that's pending leave before the Divisional Court. So later this summer, we will have an answer to those. I can tell you that FSCO is not accepting for arbitration cases that are deemed failures by the passage of time through the mediation process. They are simply sending out letters advising that the matter is under appeal and that in the meantime they are continuing to apply their standard formula. So for an insured who wants to use the arbitration process because they think the case law may be more favorable to them than what judges are doing, they're kind of stuck by FSCO. But for an insured who's content to take their claim because it's big enough, perhaps, through the court process, they are, at least until the appeals are heard, are able to immediately do this. And of course, all this can happen before an insurer even knows that there's been a request for mediation, because that application for mediation sitting in the in-bin at FSCO and not waiting to be sent out. And if I could put in my 2 cents, I don't think that FSCO is really adequately dealing with the problem that the courts and their own arbitrators are pointing out to them. We will see their mediation backlog reduction plans go into play this summer, and so you're going to see a lot more pressure to get on with these mediations and to use the computerized scheduling. The only other thing I would point out to you is that the superintendent's report on the definition of catastrophic impairment has been posted on their website. It's the superintendent's recommendation. The next steps are political, and we know that those take a while. You will see that the changes that they're recommending have to do with moving towards more evidence-based and treatment-based conclusions. And so one of the things they're removing, for instance, is simply the Glasgow Coma Scale score at the scene of the accident, resulting in a catastrophic impairment. Immediately you'll see the changes there in terms having a lot more to do with what the actual outcome was of that injury. So please send us your questions. We have some already.
I can answer the first if you'd like.
Okay, go ahead, Shawn.
First question we had here was an understanding that the word indirectly had actually been removed from the SABS schedule prior to 2010. And I think you're right on that. The importance here is that it's actually in the case law that is lingered. And the Ontario Court of Appeal made an interesting observation on that point. In the Downer case, the Court of Appeal's decision overturned a lower court's decision and held that the court had applied the incorrect test. And the Court of Appeal was very clear in that the question was whether or not the use or operation of the motor vehicle had directly caused the injuries. In the Whipple case, they applied the test that was actually held to be erroneous by the Court of Appeal, so it'll be interesting to see if any other cases like that are appealed. But the indirectly in that one, where it arises and where the court upheld the director delegate's decision, is on the chain of events, and that case dealt with a chain of events. So in terms of reconciling these two cases, what I think we need to look at and focus on is the chain of causation versus an intervening act. In the first case, Downer, there's no doubt that the presence of the assailants and the attempted carjacking was an intervening act. On the Whipple case, clearly the presence of a stripper pole didn't give rise to a finding of fact that a headstand and subsequent injuries were predictable, But what the court did focus on was the presence of alcohol, the presence of the stripper pole, definitely invited cavorting around the stripper pole, and they agreed with the director delegate's decision that the cavorting gave rise to exactly what happened, which was described in the plaintiff's terms as a series of one-upmanships, where the guys were engaging in increasingly risky and trying to be funny behavior that essentially gave rise to this gentleman attempting a headstand.
Okay, so don't forget, we're going to send the presentation out to you. So we'll have the notes for you right in that email. And if you have questions coming out of this, could you send us an email? Shawn Van Helden and myself, Shawn O'Connor, would be happy to address any questions you've thought of after the webinar is over. I want to say thanks again for joining us, and we look forward to doing this again in the future.